What can you do about overly aggressive HOAs in Florida?
Hi guys.
This is pretty much been explained.
Jonathon Daily.
HOA power trips. Watch these clips. Hope you think they're funny.
What you got cooking over there?
Some dogs for the kids.
You know you're not allowed to have a barbecue visible from the road, right? And clean up your yard.
So yeah, the HOA power trips. Everyone, or not everyone, but a lot of people in Florida call us regarding these kinds of cases, and maybe you've had personally experienced it yourself. What can you do about overly aggressive HOAs in Florida? Well, there's a number of different things we can do, but of course, the main things, your main arguments are typically going to be disparate treatment, selective enforcement. HOAs can't selectively enforce rules against one person. They're not enforcing against everyone. So if you get a crazy complaint because the board member just doesn't like you, then they better be enforcing that crazy rule or whatever violation against every single person in the HOA. There's a couple cases on this: Chase versus Condo Association of Ocala, Prado versus Wall, White Egret versus Franklin. Another big thing that we can do in Florida is we can make an official request for records under Florida Statute 720.303, subsection 5. You have the right to request violation records, fines, history, meeting minutes, architectural control designs, enforcement logs, covenants, bylaws, and amendments. The HOAs must provide this within 10 days or face a 50-day penalty up to $500 and legal exposure. These records will often expose the inconsistent enforcement, biased enforcement, procedural failures, so that's leverage that can really help you out. One tidbit on this statute is if the HOA makes available a website that you can access that has your records, has this information, then that is sufficient and they don't have to submit you a giant portfolio of paper that shows all their different records. You can send a demand for pre-suit mediation, challenge the violation on procedural defects if they don't give you proper notice in a hearing, file a complaint with the Florida Department of Business Professional Regulation. They're not technically covered by HOAs. HOAs are not technically under their jurisdiction. However, they will hear complaints, especially about board member misconduct. So if you got a crazy HOA, give us a call. We'll make something happy for you. And one of the biggest things that you have leverage of is if you can win against your HOA in litigation. The prevailing party is entitled to attorney's fees according to Florida Statute 720.305 subsection 1. So attorney's fees are a big leverage that you can use to get rid of the inconvenience and the unreasonable HOA power plays that they may make against you. And again, there has been some statutory reform recently that has really taken the powers away from the HOA it was designed to. So if they're still giving you a hard time, give us a call and we will help you out.
For the latest in case updates, legal tips, news, and politics, make sure to like us on Facebook, follow us on Instagram and our other socials, and above all, subscribe on YouTube to get your dose of excellence on a daily basis.